Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Ladies and gentlemen and children of all ages, welcome to Kirk's Law Corner Live with Kirk Pendergrass and Chris Hallett.
What is happening, ladies and gentlemen? We have a show for you tonight. This is just ultimate groundbreaking news that's just awesome, as the rule of law is getting, again, the smackdown from President Trump this time. As of December 6th, this proclamation that we're going to go over tonight, and then we're going to go into the Jeff Sessions, who laid down the rule of law again, November 16th, with his document. We've already gone over it once before, but we kind of want to tie the two together now, kind of get a really good idea of what's going on up there at the top of our government and what's really going on, because this is important. Because not only did Chris follow what President Trump put out there March 23rd of 2017, which was, we're going to do an audit of the entire executive branch, and we would like the people's help on this. So Chris actually took that literally and did that.
Did what I do.
That's what's going on. So I want to thank you all for joining us tonight. And seriously, this is some serious information here that we need to comprehend and understand what's really going on. So share, because this is some great stuff. If you haven't, I mean, I put this sucker out as soon as I come across it, and I make it a point to check this stuff once a week at least. I check the DOJ website and the White House website for anything new that has come out. And so yeah, share, because this is seriously good information here. Now
yeah, to let everybody know, today, well, I was out actually working. I wasn't even messing with courts today. I was actually out doing my real job. And I heard from 4 different parents that, and actually one who's involved in another case that's quote unquote criminal but civil, one of those deals. There's been a major octave shift in their cases versus, a couple, 2-3 weeks ago when they would have been told, shut up and go home, you're stupid or drunk or whatever. That's not what's gone on just in the since this morning. I'm hearing it from pretty much everybody I've worked with saying, dude, I actually got somewhere in court. They didn't throw me out. They actually sat there and listened to what I had to say. So you're absolutely right, Kirk. There's been it's not just a shift in the law, it's a shift in the practice of law, which is where it needs to happen.
Exactly. And I have Christopher Hallett's paperwork here printed out, or at least the 38 pages of it, with the Jeff Sessions letter and the DOJ letter, the Dear Colleague letter, preparing a deal paperwork for a friend of mine who I'm going to attempt to actually represent him in court. I'm going to assist him, assistance of counsel. I do not need a license to practice law. I am prepared to go to jail if I have to. But where I'm at is, this is my law, and the rule of law says not only does every man have the right to assistance of counsel of their choice, But in the Declaration of Independence, we have a duty to come to the aid of our fellow man.
That's right.
There's a couple of legal maxims out there that I like, and one is what a person does in their defense is to be considered legal.
Right.
Okay. The defense in their person is to be considered legal. That's a legal maxim. So, coupled with the Sixth Amendment, which says they have the right to assistance of counsel of their choice. It doesn't say that in the Constitution, but let's go back to the Virginia Declaration of Rights, because that's where it actually says that, the assistance of counsel of their choice. And nowhere in law does it say that you have the right to an attorney, and if you can't afford one, one will be appointed for you. Nowhere in law does it say that.
Yeah, that's the Miranda warnings that were devised based on some guidance document somewhere. Correct. To steer you where they want you, right?
Yep. Okay. And yeah, somebody said PAG, Private Attorney General. That would be a John Patton. Essentially, that is Private Attorney General, doing a power of attorney. So I have the power of an attorney, but more specifically, it's the right to assistance of counsel of his choice. So we can't convert that right into a privilege, license it, and attach a fee to that. Not only that, my argument goes further than that, is the fact that where does the bar fall under an agency? What agency do they belong to? Because Title 74, Section 201 of the Idaho Code says, we, the people of the state of Idaho, do not yield our sovereignty to the agencies so created. So what agency is this? And is it under control of the executive branch and the people? Because the people create the agencies and consent to the agencies. And what our consent is the legislative intent in the creation of the agency. That's what it talks about, the creation of these agencies. Okay? We, the people, dictate, because we're self-governed. See, by consent only. And I've never read anywhere in the Constitution, even in the Idaho Constitution, where it says that a private corporation known as the American Bar Association or the Idaho State Bar is allowed to operate and within the state of Idaho and issue licenses. I mean, does the National Rifle Association have the ability to issue licenses to kill people?
Mm-hmm. Or having exclusivity over it, right? That's right. Called a monopoly. We can't have those.
Right. And even then, it's not even a monopoly because it's not an actual agency of the state.
Well, if
by we the people, therefore it's just a private corporation like McDonald's. And there's McDonald's. Does McDonald's have in their policy have the ability to tell Burger King and Wendy's how they operate, and that they need to seek permission from McDonald's to function?
Right.
How about the employees of McDonald's? Do they have to seek that license in order to practice flipping burgers back there, making French fries? No.
Well, that's
convert that right into a privilege, license it, and attach a fee to it. And when we get to property essentially is our rights, our guaranteed fundamental rights. Any rights that are fundamental, those are guaranteed rights.
Those are yours. They belong to you.
Correct. So along that lines, cannot play video. There goes my phone. The first time, we're not even 10 minutes into the show, my phone's crapping. So, there's, where is it? Come on. Oh, I don't have it open. I better open it. Some American jurisprudence. Law library.
One of the 7 danger signs you're doing something right is when the ones who are trying to maintain control over their whatever the fictitious BS is they think they're controlling come out and start attacking you left and right. So, Well,
and I'm sure they will.
Oh, no, they're attacking the shit out of me, and I think it's hilarious because, as far as that goes, I've been threatened everything from you're going to spend the rest of your life in jail to, you name it. You know the threat I've experienced it in this last year. And I just laugh in their face and say, you know what? Bring it. Go ahead. You show me in law where it says that, and we'll discuss it. And oh, by the way, we're going to put it in front of a jury.
Right.
Because if you're going to be the moving party, guess what you have to prove?
Yeah. You better get on that judicial notice of the actual law, because you're going to be asking for it.
Yeah. Show me in law where it says you have the exclusive right to practice. Show me that. Because you can't.
So let's jump into 16 American Jurisprudence, Second Edition, Constitutional Law, Section 100. This is as of August 2017 update. So this is pretty darn current. Okay. A constitution is usually a declaration of principles of the fundamental law. Okay. Many of its provisions being only commands to the legislature to enact laws to carry out the purposes of the framers of the Constitution. We, the people, are the framers. We establish justice. That's the preamble to the Constitution of the United States of America. Okay. We, the people, establish justice. We do. Not the legislative branch, and most definitely not the judicial branch. Okay. So, of the Constitution, or mere restrictions upon the power of the legislature to pass laws. Imagine that. The Constitution limits what they can and can't do.
Right.
It's a limiting compact or contract. Let's just get that out there. This is a contract in writing and enforceable in any court of law. And we'll get to that right here after I get done reading this.
Right, which takes my favorite.
Entirely within the scope, entirely with the power. It is entirely within the power of those who establish and adopt the Constitution to make any of its provisions self-executing. That is operative without any necessity for further legislation, such as the Bill of Rights. The actual first 10 articles is the Bill of Rights. As an addition, articles in addition to, and an amendment to the Constitution. So they are articles. Article 1 through 10 is the Bill of Rights. They are articles in addition to the Constitution as an amendment. So the Bill of Rights as a whole, all of those articles are an amendment to the Constitution. Those were not individual amendments to the Constitution because it never amended anything in the Constitution. So that right there is operative without any necessity for further legislation, because this is a declaration of principles of the fundamental law. That's why we call that the law of the land, the supreme law of the land. Okay. And that's why Article 6, Clause 2 specifically says anything in the Constitution or the laws of the state to the contrary are notwithstanding in law. So if anything in your state constitution comes in conflict with the supreme law of the land, it is repugnant. It is void from its inception. And most definitely, any of the statutes, rules, and regulations, policies, guidance documents, they're all void from its inception as of November 16th from Jeff Sessions. He put the kibosh on that, prohibition on guidance documents. All of those are guidance documents. None of that is law. Okay?
And what's the Constitution call those guidance documents? We've discussed this. Mm-hmm. Bills of Attainder, right?
Article 1, Section 9, and Section 10.
Correct.
Criteria which may be relevant in determining whether a constitutional provision is self-executing or not include a description of the right in detail, such as the means for the enjoyment and protection, the absence of any directive to the legislature to further action, a particular informative legislative history as to the provision intended operation, and a consistency of self-execution with the scheme of rights established in the Constitution as a whole. Now, observation. Even without the benefit of a declaration that they are self-executing, constitutional provisions in bills of rights. That is plural, more than one. We have lots of bills of rights. Okay, clear back to the Magna Carta, and maybe even further back, as far as I found, is the Aziz of Clarendon from 1166, which is before 1215 of the Magna Carta. Okay, some of our rights go clear back to there. That's as far as I've gotten in history so far. So bills, provisions in bills of rights, and those merely declaratory of the common law are usually considered self-executing, as are provisions which specifically prohibit particular conduct. A clear distinction exists between the questions whether a constitutional provision is mandatory or directory, and whether it is self-executing or requires legislation in order to give it effect. The provision may be mandatory without being self-executing, and a provision may be self-executing even though it contains some mandatory language. Okay, everything in the Bill of Rights is self-executing. It does not need the assistance of the legislature in any way, shape, or form. And in fact, when you read certain other actual amendments to the Constitution, right here, power to enforce amendment. This is amendment number 15. The Congress shall have the power to enforce this article by appropriate legislation. You will not find that wording at all in any one of the first 10 amendments. None. In fact, number 11 doesn't. Number 12 doesn't. Number 13 does. And I believe, yep, number 14 does. Number 15 does. I mean, so there's your evidence right there. If it doesn't say that Congress has the power to enforce this article by appropriate legislation, that is declaratory of the common law. It's a fundamental principle of law, which means it doesn't need the assistance. And I've gone into this with my treatise on arrest and false imprisonment. There is no authority to make statutory law regarding the law of the land or the supreme law of the land, that due process of law that is due to everyone as a human being. Okay, that's what that says right here. And let me get into this other one, just to really hammer this, because this is so awesome. 15M Jurisprudence second edition, Civil Rights section, section 2. Okay, Westkey Digest number 1001. Natural rights, which have been described as those rights which appertain originally and essentially to each person as a human being and are inherent in his or her nature, as contrasted to civil rights. So there's a difference between natural rights and civil rights here, okay? Which are given, defined, and circumscribed by such positive laws enacted by civilized communities as are necessary to the maintenance of organized government. It has been said that political rights are included within the more comprehensive term civil rights, but that they are differentiated in that a political right is a right exercisable in the administration of government, or a right to participate directly or indirectly in the establishment or management of government, okay? While civil rights have no relation to the establishment or management of government. We all understand that right there?
Absolutely.
Natural rights and civil rights have no relation to the establishment or management of government. There is absolutely no legislative authority, period. There is no authority to manage that legislation or even manage the right, okay? Because we're talking about the common law. That's why the Seventh Amendment reads the way it does.
Right. I mean,
by jury in civil cases, in suits at the common law. What do you mean it suits at the common law? You talking about stare decisis? No. We're talking about what I just read to you. Bills of rights, declarations. That's the common law. So suits at the common law, natural rights and civil rights, which have nothing to do with the establishment, support, or management of the government. Okay? That's how our form of government is supposed to be and was limited this way by Constitution, by bills of rights. That's the common law, okay? Where the value in controversy shall exceed $20, the right to a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rule of the common law. Common law. Okay? That's what we are coming back to right here, right now. You got anything to add to that, Chris?
Well, it just, the key word there is limited, right? What can they not do, right? And, up until, just recently, it was, it was nothing but a snow job, snake oil salesman. Like that's what I said it in my report, well, we should do this because we think we need to protect the people. So that's how they basically sold all of this bullshit, for lack of a better word. We need this to protect the people. Guess what? This has all been done before, right?
Yeah.
And saw a commercial the other day where it says the new buzzword is democratic socialism. So now wait a minute. Just because you put a new descriptive adjective over something somehow changes it, right? No. Democracy is democracy, socialism is socialism, and neither one of those actually fit our form of government. Our form of government is a republic based on the democratic principles in election times, right? So
that is the only thing that we do democratically is we elect our representatives in government. This right here, what we created. Okay, without this Constitution, government doesn't exist. It's a figment of the imagination, right?
Mm-hmm.
We all understand that, right? That the Constitution is actually what creates our form of government in writing. Okay?
Right.
Like it says, we the people establish justice.
Right.
We're basically creating these positions in government to protect the common law, to protect our rights, to ensure domestic tranquility. Still, again, haven't really found a definition of that one. I have not looked in the Beauvair's Law Dictionary from 1856 yet, but
I have. I wish I could say I had time to dig into it, but I haven't either.
Right.
As you can imagine, my phone blowing up.
Article 10 of the Bill of Rights: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Okay, so the Constitution in Article 1, Section 8 delegates certain things to the federal government. Okay, so right there where it says the powers not delegated to the United States by Constitution. So the powers that are delegated to the federal government are limited or prohibited from going to the states. Okay. Because, we're splitting up the powers here is what we're essentially doing when this Constitution was being created, because, we had the Articles of Confederation where we didn't have that separation. Okay. So somehow they decided to do this Constitution and, federalism, having this centralized government. So the powers as a whole in the Union, to form a more perfect union here, the states, we the people of the states, delegated certain powers to the federal government. And when that happened, the states no longer have that power. Okay, that belongs to the federal government. Taxation is one of those things. Come across my feed today. And it says, nor prohibited by it to the states. Okay. When we look at Article 1, what's been limited? Well, we were just talking about there. Article 1, Section 9, Clause number 8. No title of nobility shall be granted by the United States. No person holding any office of profit or trust under them shall, without the consent of the Congress, accept any present emolument, there it is, emolument, office or title of any kind whatever from any king, prince, or foreign state. Okay. Number 10, actually, let's back up to number 9. Number 3, no bill of attainder or ex post facto law shall be passed. Article 1, Section 10. Okay. Number 3. Where was it? Number 3?
Just short circuit.
Okay, it is 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold, silver, coin, attainder, and payment of debts, pass any bill of attainder. Okay, so we need to understand that what's going on here. What's bills of attainder? Bills of attainder, bills of pains and penalties. The shortest definition out there is legislation, comma, punishment. So if there's any legislation that prescribes punishment, that's a bill of attainder. Can you think of any statutes out there that have been created that prescribe punishment?
Damn near all of them.
Right. Imagine that. So those are guidance documents, which is what Jeff Sessions just put an end to. Because, again, what I just read there, the common law side of things and fundamental rights, the fundamental law has nothing to do with the establishment or support of management of government. Okay? This is the law. You're supposed to uphold this as it is written. You're not at liberty to disregard our commands. Okay?
Back up just a second there, Kirk, because the statutes that were, quote unquote, passed by Congress require implementation through the practice. In other words, require somebody to take an action against you, which would be, in normal context, the prosecutor, correct? To establish this fee that you're supposed to be paying or this penalty that you're supposed to endure or blah, 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 blah. So what the guidance document letter does is it basically prohibits the prosecutors from prosecuting unless they can prove beyond reasonable doubt, established jurisprudence, that you are guilty of something that is written in law. In other words, you can't just walk out, make an allegation. This person did this. Now I'm going to invoke this punishment, because that's what they've been doing, right? And by killing those guidance documents, he's basically told the prosecutors, agencies, whatever, no, you're not doing that, right? That's the shit that we declared independence from 230 years ago, right? So
exactly where I was going.
We transition from what the rule of law says to when, where, why, and how it's practiced, right? Those guidance documents are the when, where, why, and how it's practiced. And Sessions just came out and said, this is what you can put in a guidance document. This is what you cannot put in a guidance document. Mm-hmm. Your agencies, in other words, like you said, McDonald's can't tell Burger King how to flip a burger, right?
Yep.
That's what it boils down to. So to recap this, we've basically limited government, going back to that word, because the Supreme Court in there, every decision in a limited government, right? So when we talk about institution, or implementing constitutional law in a limited government, it always starts with that phrase. That's the reason it's there. So, and again, this boils down to the practice of law, not what the law says. The law says what it says. It's how they're using these guidance documents to practice it however the hell they want, right? And finally, the people stepped up and said, no. So, and now that we're standing up and saying no, what choice do they have? They have to back down. I mean, it is what it is.
I mean, these are declared acts of tyrants here. And so I actually want to go over this just before we start the proclamation here, because when we put this all together, you should be able to get this, okay?
It makes sense.
For suspending our own legislatures and declaring themselves invested with the power to legislate for us in all cases whatsoever. That right there is a declared act of tyranny. See, that's not how our form of government is supposed to work. Again, back to Title 74, Section 201. The people of the state of Idaho do not yield their sovereignty to the agency so created. We say, we consent how that agency will operate in our state. Okay? And how, basically, that applies to any corporation. Okay? Private corporation. Okay? You have to follow the statutes. And then you have to have your bylaws. And your bylaws have to be in accordance with the legislative intent and allowing you to create your corporation, private corporation. And the same goes for any agency under any department head is by consent, legislative intent. Some of it comes from the Constitution, but at no certain time do any of those statutes, their rules of procedure, policies, corporate policies, none of those at any time are enforceable as law onto the people. Only the agents of the agency or members of the corporation or employees is the actual operative word there, because no matter where you're at, in the private sector or in government, you're an employee. You're a public servant. If you're in government, you're a public servant. Okay? You serve us, we the people. And again, you're not allowed to disregard our commands. In fact, you're supposed to take an oath of office or affirmation and affirm your position in employment in government. Because again, we created those positions. And Article 6, Clause 2 and Clause 3 specifically, everybody from the legislative branch, executive branch, and judicial branch shall be bound by oath or affirmation, okay, to support this Constitution, this one. So this is the rule of law. That's what it says, and that's what we're going to dig into big time right here. Ready for this? Got all your shares out, got your friends here, because this is important, folks.
Hit me, baby.
Seriously, pay attention. Proclamation. President Donald J. Trump proclaims December 10th, 2017 as Human Rights Day. December 15th as Bill of Rights Day. And the week beginning December 10th of 2017 as Human Rights Week. This was issued on December 8th, 2017. Our great country was forged in the fires of a revolution to overthrow the rule of a tyrant. This Declaration of Independence declares acts of tyrants. I just read one of those to you. By a free people who understood the fundamental truth that liberty is best secured when the state's power is carefully limited. From the Declaration of Independence to the Constitution and through the Bill of Rights, our country and our people have always known the true God-given nature of liberty and the ability of law to safeguard it against the state. For 226 years, the final piece of this freedom-sustaining bulwark, the Bill of Rights, has formed the bedrock of the constitutional protections every American holds dear as their birthright. Okay, by blood. On Bill of Rights Day, we recognize the importance of the first 10 amendments to our Constitution to protecting our liberty and freedom against the inevitable encroachment of government. Our founding fathers understood the threat of expansive, omnipresent government from the beginning of our republic. Therefore, they endeavored to enhance the Constitution with the Bill of Rights, a specific enumeration of fundamental rights that would prevail even against a future government inclined to abuse the power it has over the lives of citizens. On June 8, 1789, James Madison, originally skeptical of the need for a Bill of Rights, which he was, introduced in the Congress several amendments to the Constitution that would eventually form the Bill of Rights. During the ensuing debates, Madison told the Congress that because all power is subject to abuse, it was worth taking steps to ensure that such abuse may be guarded against in a more secure manner. Many of the rights set forth in the amendments Madison introduced that day are quite familiar to us as Americans. The right to worship as we please, the right to speak our minds and our consciences, the right to firearms to protect ourselves and our loved ones, the right to be free from unwarranted government searches and seizures, the right to a jury of our fellow citizens when accused of legal wrongdoing. Others, like the right to object to housing troops in our homes during peacetime, are often thought as relics of a bygone era. Regardless of their familiarity or applicability to our daily lives, however, each clause of the Bill of Rights addresses profound and real abuses the founders faced, and each is crafted and locked into law to protect us and future generations from their repetition. Okay? This stuff was fresh in their mind when they made these, okay? They just got done with the Civil War. Lots of people died, lots of bloodshed for this, okay? Since its adoption, the reach of the Bill of Rights has spread far beyond America's shores. As George Washington rightfully said, liberty, when it begins to take root, is a plant of rapid growth. For example, in the wake of the devastation of World War II, the spirit of the Bill of Rights inspired the United Nations General Assembly to adopt the Universal Declaration of Human Rights in 1948. Just like the Bill of Rights, the Universal Declaration of Human Rights is grounded in the recognition that just governments must respect the fundamental liberty and dignity of their people. By enumerating core rights that should be immune from government encroachment, what did I just say there? They have nothing to do with the establishment, support, or management of government. So that's what we're talking about there. By enumerating core rights, these are fundamental principles that should be immune from government encroachment, even the slightest encroachment. There is no authority. Both the Bill of Rights and the Universal Declaration of Human Rights have helped fuel remarkable prosperity and achievement around the world. During Human Rights Day, Bill of Rights Day, and Human Rights Week, we rededicate ourselves to steadfastly and faithfully defending the Bill of Rights and human rights. Our God-given fundamental rights are soon overcome, if not safeguarded, by the people. So let's get with it, people. We, therefore, also reflect upon the many individuals who are unable to enjoy the God-given rights that we as Americans know are secure. We remember those suffering under the yoke of authoritarianism and extremism for doing nothing more than standing up to injustice or daring to profess or practice their religion. And we acknowledge those imprisoned or in peril simply because of their political views or their sex. Now, therefore, I, Donald J. Trump, President of the United States of America, by virtue of the authority vested in me by the Constitution, imagine that, the rule of law, and the laws of the United States, do hereby proclaim December 10, 2017 as Human Rights Day, December 15, 2017 as Bill of Rights Day, and the week beginning December 10, 2017 as Human Rights Week. I call upon the people of the United States to mark this observance with appropriate ceremonies and activities. Let's get active, folks. Seriously. Let's get serious about getting active, because that's what President Trump just said. Get witness whereof I have hereunto set my hand this 8th day of December in the year of our Lord, 2017, and of the independence of the United States of America, the 242nd. 242 years in the year of our Lord since the Declaration of Independence. We've been derelict in our duties. So I'm going to go back to the Declaration of Independence. We're going to talk about some of these duties. When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitles them. Okay? A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. So these are declared causes of the separation. We hold these truths to be self-evident. Okay, these are self-evident. Okay, that all men are created equal, that they are endowed by their Creator with certain unalienable or unalienable rights, the common law, natural rights, which have nothing to do with the establishment, support, or management of government. That among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. From the consent of the government. Okay? From the consent. Us, we the people, we're self-governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes. Okay? Not light and transient causes. And accordingly, all experience hath shown that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under the absolute despotism, it is their right, it is their duty. So not only is it a right, it's a duty to throw off such government and to provide new guards for their future security. Such has been the patient sufferance of the colonies, and such is now the necessity which constrains them to alter their former system of government. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over the states. To prove this, let facts be submitted to a candid world. Okay? There's all these lists of acts of tyrants, and we've gone over these before. But, he has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. What do you think they're talking about there? Something like FBI, BLM, CGS. Okay? He has kept among us in times of peace standing armies without the consent of our legislatures. That's called police force. Okay, we abolished police force. We only have military force. All supposed to be from the militia. I've gone over this already. We have three parts of the militia. The unorganized militia, and that's the reason why the Second Amendment reads the way it does, is that the right of the people to keep and bear arms shall not be infringed. And again, that is declaratory of the common law and does not need any further legislation. In fact, it's not authorized. It says, shall not be infringed. Nowhere in after that wording there's a period there, nothing there that says the Congress shall have the power to make legislation regarding this amendment. Okay? It's not there. It doesn't exist. There's no power delegated there. None. None was delegated. There is no power to make statutory law regarding any of the first 10 articles of the Bills of Rights. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. The bar? That be what we're talking about here? Pretended legislation that, you have to have a license to practice law. Oh yeah? Where does that say that in law? Because that's a declared act of tyranny right here, and I'm going to read it to you.
Dusty in here.
Right? for quartering large bodies of armed troops among us. Quartering, that's quartering them up in homes. Okay? They may not be directly in my home, but they're my neighbors. They're quartering up in our homes. They're being paid as a police officer and quartering up in our homes. That's unlawful. That is not authorized by law. It's prohibited by the Declaration of Independence. We have a military. That's it. Again, back to the Second Amendment. The right of the people to keep and bear arms shall not be infringed. Not only to ward off a despotic government, but to protect life, liberty, and pursuit of happiness as a natural right. That is the law of nature. We have the right naturally to defend our life, our liberty, our property, our pursuit of happiness with arms.
Yeah, we don't have just...
It has nothing to do with the establishment, support, or management of government.
Yeah, it's our duty to do it. If we don't do it, nobody will.
Right. For imposing taxes on us without our consent. Well, I'd sure like to do an audit of all these taxes that have been imposed, because it has to be put to a vote. Again, back to this other one here. For depriving us in many cases of the benefits of trial by jury. Ooh, that's a big no-no, ain't it? That's called bills of attainder. That's where bills of attainder came from. That's why they wrote Article 1, Section 9 and 10 the way they did. Right there. For depriving us in many cases of the benefits of a trial by jury. That's tyranny. That's an act of a tyrant. But more specifically, that one right here where it says, for suspending our own legislatures and declaring themselves invested with the power to legislate for us in all cases whatsoever. That's what they're doing. They're not supposed to be legislating for us. There's no power delegated to do that other than what has been specifically delegated, which is for all things foreign in the federal government. Okay? And what's left over is reserved to the states or to the people. But there's no legislative authority to deal with the common law. Common law takes care of itself. That's where you and I live as a human being, as a man, a woe man. Okay? That's where we live, is at the common law. Our rights are our property. Any guaranteed right is your property. Black's Law Dictionary. Any one of the Black's Law Dictionaries, Bovier's Law Dictionary, same thing. Property. Very first one is a guaranteed set of rights. Natural rights and civil rights are guaranteed rights. Those are fundamental rights. Fundamental principles of law. The rule of law. That's the rule of law we're talking about. So, yeah, we need to get educated on what this is, what your rights are, where they come from in law, so that you can go, well, wait a minute. This is what the law says here. This is the rule of law. Who are you? Because your creation, we created your position in employment, correct? Right. And you have your oath of office on file, right? You got your surety bond on file, right? Okay. So you're supposed to support this Constitution. And in fact, you're not allowed to go outside this and act outside of this. Delegations of authority. Oh, by the way, ignorance of the law is no excuse. But I'm going to cut you some slack, and I'm going to come to you with my Christian love and forbearance. And, maybe you just didn't know. Maybe you got brainwashed like I did. Well, I didn't quite get brainwashed as a kid. But in today's day and age, what they're teaching in school is this Constitution don't mean anything. And in fact, I just had a discussion with a previous public defender down at the courthouse while I was with my friend Chuck in court, discussing what's coming out from Jeff Sessions and, E-clause and all this stuff. And he's like, well, the Declaration of Independence, it's not law. It doesn't have anything to do it. And I pulled this book out and I said, what does that say right there? I said, that says the Idaho State Constitution, the Declaration of Independence, and the United States Constitution. That's the seal of the state of Idaho. And that's the Secretary of State of Idaho that just printed this out. This is the 2017 edition. I said, the Declaration of Independence most certainly is law. And in fact, it's the supreme law. And it came before the Constitution. And he just looked at me. He's like, well, huh. So these people are going to have a rude awakening come January 10th when I come into court with, by the time I'm done here, it's going to probably be around 100 pieces of paperwork that I file with them. Bringing the rule of law back with Jeff Sessions' letter, which we'd like to go over now. If Chris, you'd like to go over that. And then this is the proclamation from President Trump. Okay? It's reestablishing the rule of law. Fundamental truth. Fundamental law. Principles of law. And he's asking, I mean, he flat out tells us in there, he's asking the people to get up and do this. I mean, it's exactly
I'm working.
Yeah, the people, that's plural, not the person.
Right.
Not just Christopher Hallett over here, not just Kirk Pendergrass over here in Bozo, Idaho. We need, and this is part of what I keep putting out there, is we're looking for people that are in, professional, like-minded people, because we need people like myself and like Chris in each state to start getting a hold of their legislators, getting a hold of their representatives in government, getting a hold of their governors, getting a hold of the Supreme Court justices of the state, and say, look, here's the law. Here's a proclamation. Here's Jeff Sessions' letter. Oh, by the way, here's a practitioner's report from E-Clause, practitioner's judicial report. That's an expert witness, by the way. Any practitioner's report is considered an expert witness. So that's what we're looking for. We're looking for people that, might have some big balls and just start doing this. It ain't going to change itself, and Trump's trying to do what he can from the top, but he's asking the people for help. He's given us the power. All we got to do is stand up. We don't necessarily want to complete that circle of history. There's a part in there that, the very first part of the circle, we don't want to repeat that. Not if we can avoid it. But I know damn well there's lots of people in this country that are prepared, that are ready, well-armed, well-educated, well-trained, that are definitely willing to go that route if we have to. But, we're supposed to be treating each other with Christian love and forbearance, and we're supposed to be 226 years down the road. We should be able to be civilized about this, and we should be able to talk to them and say, look, what you're doing is wrong. Plain and simple. Here's the law. Here's the evidence, because that's how anything is supposed to work. Here's the evidence. You don't get to just say what it is. Okay? You got to provide the evidence. So let's get into some more of that evidence. Christopher Hallett, with your Jeff Sessions letter.
Oh, you want me to pull the letter up? I can absolutely do that. That's a
prohibition on guidance documents.
Oh, yes. In other words, you cannot walk into any, any agent from an agency cannot walk into a courtroom and say, my policy is law in this room. And that's what they've been doing.
Right.
And
subversion.
Yeah, exactly.
Treason by sedition.
Oh, I wasn't going to say that, but since we were making it anyway.
I'll call it what it is. That's treason by sedition.
Yeah.
So the law, acting under color of law, is an act of treason.
Correct.
That's giving aid to our enemy, our declared enemy. Declared. And it's written in writing. We know that the legislative power doesn't have the power to legislate for us.
This is true.
In all cases whatsoever. The common law is the common law. And that's the proper jurisdiction on the land. There's only two jurisdictions that are lawful. Article 3, Section 2. And that is the common law and the law of equity. And the law of equity deals with contracts. An equitable interest in a contract or property, real property, which is more of what Chris actually has started out doing 29 years ago with real estate.
That's what got me started in all of this.
It's a pretty good training ground, huh?
I'm telling you, it was an education like nothing I've ever had.
Yeah, look up sedition, John, there at Title 18, Section 2383 or 2384. 2381 is treason, and that's Title 18, Section 2381 is treason. And there's like 4 or 5 of them there that all fall under treason.
Basically, he says this the most beautifully in his first 2 opening sentences. I mean, that says it all. The Department of Justice has the duty to uphold the laws of the United States and to ensure the fair and impartial administration of justice. Right? Fair and impartial administration of justice. Okay? So you want to talk about domestic tranquility? Fair and impartial administration of justice. He further goes on to, therefore, when the department engages in regulatory activity, it should model the lawful exercise of regulatory power. What does that mean? In a limited government. In other words, to limit themselves, not to limit you and me and everybody else watching the show here tonight. It is in a limited government. So when you talk about, well, we need government for this and we need government for that. No, no, that's not how this is played. And anybody who's told you otherwise is trying to indoctrinate you, right? And we've had that conversation on more than one occasion.
What's the old saying? Question everything.
That's right. Nothing.
Twice.
That's right. And it's measure twice, cut once. I'll get that right one of these days.
I measured it twice, and it still too short.
That's right. So, when you're talking about how you implement what the law says, it's one thing to know what the law says. It's something else, like Kirk says, when you walk in there into any courtroom, and it doesn't have to be just family law. We talk about what the law says on this show. That's what it is. So I was wanting to have my one client come on tonight and talk about his case, but because his case was actually a criminal case in nature, and some things have actually really happened for him that are really, really good. So under advice of counsel, that's me, I said, hold off on doing the show until we can make sure that they're going to comply and follow through with what they've claimed they're going to follow through with. So they know they're on a limited clock, and he is going to come out and he's going to explain to you guys what we did for him and why it's been so significant.
Good.
But because they've agreed basically to come in and clean up his case, and he actually got that news this morning.
Nice.
We've said, okay, until that happens, and there's, because there's movement, and until that happens, you need to kind of hunker down, keep doing what you've been doing. We can do a show at any time. It's no problem. So, but basically the long and the short of that is, without going into detail, and everybody should already know this anyway. When you talk about good standing, what does good standing mean? It goes into how trustworthy are you, right? Are you as good as your word, for example? Mm-hmm. So when they throw these allegations at you, right? When they throw these allegations at you, it is nothing more than an attempt to impugn your integrity or your good standing in court, right? In other words, make it so you're not believable, right? And because there has, these regulations, these guidance documents have basically told them that, yes, that's exactly what you're supposed to do to achieve your goal. Well, that's literally prosecution by proxy, for lack of a, to kind of break it down a little bit. And, to go through and for us to explain, what all law they broke. Everybody knows they broke the law. Every case is a little different. In my case, it was 18 USC subsection 643, malfeasance of office resulting in unjust enrichments. Well, those are emoluments. So,
yeah,
it's just a, so basically when you're taking and you can definitively say, well, how do I fight this? Well, the answer is you take in and you drop in a contrary positive. They walk in and say, there's abuse or neglect in your case. Could be a family law. It could also be a case where there's an elderly person, right? Because here in Florida, we care for the elderly people much in the same way we care for children. So it's basically, you got both ends of the spectrum. You got, like my dad says, you come in naked and no teeth, and you go out with naked and no teeth. So it's the same thing. So, so basically it,
you start out in diapers and you end in diapers.
Well, that depends. Just made it funny.
Yeah, it just depends.
So, but anyway, when you're talking about how to, impugning a person's good standing in court makes them not believable. Well, when it comes out that those issues that have been brought up are false, and you can walk in and say, oh, I have a report here from, the convening authority in this room that says, basically, like, for example, one of my clients has a DCFS report that says there was no abuse or neglect, but the attorneys failed to report that. Well, they're mandatory reporters. They have to report everything, whether it's good or bad. So when they failed to report it, and my client and I walked in and reported it, guess what that just did? That's an attack on the integrity of the court by an officer of the court, right? Because as a mandatory reporter, they didn't report it. We had to report it. Well, then what the hell am I paying this attorney for, right? So
it's more than you.
Yeah, exactly.
You're paying him for. Sure ain't there to defend your rights.
That's exactly right. So what we have done, we've introduced a contrary positive that reestablishes my client's good standing, right? Makes my client the more believable party in the particular case. And the only other actors in the room in this particular case, it wasn't even the judge. It was the attorneys, right? They're the ones who created this stuff. So that's one of the reasons why, in that particular case, we are where we are right now. And we just put a word to it that's never been used. Everybody wanted to use the word RICO. Well, that's okay to describe the process, but that doesn't say what the crime is, right? So if you walk in and claim a RICO action, chances are they're going to throw you out unless you can show them what the crime is.
Right.
That's written in law. Your favorite words, Kirk, in law, right?
That's right.
So
where is it at?
Exactly. So
burden of proof's on the moving party. Let's get with that.
Right. So not only did they fail to prove their case, they actually assisted in proving our case for us by doing what they did. And all of that happened right about the same time that I filed this report in that particular case. It was when I wrote it. And that was filed back in August of this year. This also, the version that went before Congress, which was for my case, same report, just a little different language here and there. But that went before Congress on October 10th of this year. So when you come out and you see this letter dated November 16th, I don't know about you, but I don't believe in coincidences. So whether they got a copy of the first one from August or the one from October, Doesn't matter. The point is the subject of that report is these policies, what I'd call policies and procedures from the private sector standpoint.
Mm-hmm.
Government agencies call them guidance documents. It's the same thing. It's regulatory behavior when they're on the clock, right? So
right. You're being paid. You're an employee. You're on the clock.
That's right. And when you're paid as an employee for a company, you should, at least adhere to the company standards, whatever those are. I mean, as long as they're legal.
Or how about the terms and conditions of the contract?
Right. Part of the terms and conditions of you getting paid means while you're there doing this job,
isn't it supposed to be mutually beneficial as well?
Yeah. So if you're being a cashier or you're being customer service or whatever it is the job is you're doing, you're going to follow the company rules and procedures while you're being paid, right? Well, if those rules and procedures force you to break the law, you don't have to follow those. You know it, and so do I. So
nobody is bound to uphold it. Nobody is bound to obey it. In fact, you have a duty to disregard that. And
so that's why I said, as long as it's within reason.
That's unlawful. You can't do that.
Right. So, if they want you to wear a name tag, so the boss or whoever knows who you are, that's reasonable, right? Nothing. That name tag doesn't hurt you. It doesn't bite you. It doesn't cause you any harm. So, it's, nothing unreasonable about that. So, anyway, moving on, when you talk about following an order, okay, a lawful order, one that you believe is lawful, and you can articulate why you believe it's lawful, doing it the correct way based on our system of government in good faith, et cetera, et cetera, et cetera, is a powerful tool. Attorneys, they basically, what's their fees up to now? $350, $400 an hour, or is it higher? Depending on where you are, I would imagine.
Around here in Idaho, they're around $200, $250 an hour.
Yeah, see, they're a bit behind the times compared to
paralegals are around $100 an hour.
Right. So
just to give you an idea, paralegals, the one that kind of writes your paperwork, that's $100 an hour.
Right.
In Idaho. And we're just a bunch of, hillbilly, redneck potato farmers out here.
Right. So, but anyway, this letter is actually pretty cool when you go down through and you read it. And it basically is written under the premise of what loss prevention does. This letter is something that I would generate to one of the departments within my corporation that is instituting policies that that go, kind of way off the rails. So if human resources, for example, is saying that they can fire you because your haircut is not regulation. Well, that's an unreasonable thing, right?
What you talking about, Willis?
I mean, as long as you can make it, make yourself look presentable, right? To say you have to have your hair cut a specific way with the bowl on the head and the blah, blah, blah. That would be over the top. So I would generate a letter, something like this to Human Resources and say, hey, you need to kill that policy, right? We're going to get sued because of that, right?
Yeah.
That's exactly what would happen. So, and believe it or not, that's basically exactly what I did to the executive branch. I wrote that says, hey, you can't do that shit. You're going to get sued. What the crime is called.
Thanks, Kimberly. She said, no worse than flatland corn husk and pig farmers.
Oh, jeez.
Well, I did. I raised pigs. I raised chickens, rabbits,
right,
cattle, and some sheep, and yeah.
Well, we're surrounded on three sides by water here, so one good gust of wind, and we got some pretty decent storm surge. Kind of dangerous living on the coast, but so
yeah, Neely's like, she doesn't want to charge anybody. We need to make a living, right? At some point in time. But what is it? What is a good, honest living? Because to me, if I was an attorney, I mean, I had a hard enough time when I was running my mechanic shop charging people, $65 an hour shop rate. Well, like the low around town is $87.50.
Right.
But, I think it's a little outrageous to pay somebody $250 an hour, billable hours, which they like to stretch, because I've sat right there and watched them use somebody else's document and change the names in there to my name and the other name.
Yep. And
then go into, what were you wanting to say? What's part of your affidavit, part? What is your truths here? And they just delete that section and then type in my stuff, and everything else is the same. And we're done in like a half an hour. Right.
And you get billed for 3 hours. Right.
Well, usually I don't know. Sometimes it's like about an hour or 2 hours, but you only get billed for just that. But still, I mean, there's probably people out there that send in their information and they draw up all this paperwork, and then it's like, yeah, well, that took me like 3 hours to do. So you're going to pay me, whatever the going rate is in your area. So $100 an hour for the paralegal for 3 hours to draft that paperwork, when all they did was take the information that you already gave them, went back to the last case that they had that had the same freaking document.
Right.
Because they've done this enough. They have so many documents saved that it's like, it's all the same. And all they got to do is change the words in there to fit the names and the merits of the motion, or whatever it is they're filing, the merits of that motion to fit your case, and they file it. I mean,
well, that's one of the reasons why what I do, as far as my work in the court is concerned, it's on good faith, right? For now, it's pro bono, right? If the court says that I should be paid for doing whatever that thing is that I did, they'll tell me that, right? And that's the premise that I'm going under. I haven't asked for not a damn dime other than people pay for their own filing fees, right? I mean, that you'd be paying with or without me anyway. So as far as, what I do, well, what I do is I just do what Kirk said. I take what I've written, apply your stuff to it, and submit it, right?
Yeah.
If your case requires extra research, I'll tell the court that when the appropriate time is right. But, as far as that goes, my job is in loss prevention to represent my client while maintaining the integrity of the court at the exact same time. Oh, wait a minute. That's what the practice is supposed to have been doing all along. But we can now show that that's not what's happened. And here's how we know that. So,
not that we think, we know.
We know that, right? We apply principles such as the negative nexus, right?
Mm-hmm.
Based in law, right?
Yep.
So,
it comes from this practitioner guy, is in a practitioner's report, expert witness and all that.
Yeah, I kind of threw him for a loop with that one. So, but, and I finally said, if the court wants me to be paid, the court will pay me. What I do for companies and stuff like that, that's per contracts, and that's my relationship with them, and that's all,
See, that's
client privilege.
That's separate from you're contracting your labor,
right,
to an individual. When you file paperwork and go and litigate and argue that whatever it is that you filed, and if you win, you're entitled to reimbursement for your time,
right,
and any cost that you incurred for the filing fees, the cost for every sheet of paper, for the ink cartridges, for your printer.
Right.
I mean,
well, this is all stuff that I have in my office anyway, right? That's right. Where good faith comes in, right? If you win, I win. If you lose, I lose. Right? So, under this context, it's when you're talking about getting paid for your time, that's basically what pro bono is, right? Or contingency is. So,
but their rules of procedure, you know, have the ability to, you know, compensate you for, you know, just compensation.
Right. But because I'm asking a question that's never been asked, but is based in law, well, let's start with good faith and go from there. Right. So that's what I did.
Let me ask you, Chris, let's say somebody were to go in pro bono and they win, the court can still award them costs and fees, right?
Absolutely. It's called it's called judge's discretion or jury discretion. The jury. So for example, if you walk in and ask for $5 million and the jury says, well, that's too low, we're going to award you 20. Right? That happens. I mean, there was a case
of the jury, folks.
A guy who was in the hotel room and looked through the peephole and got pictures of the naked model chick, whatever. I don't remember her name. But what she asked for was, you know, wasn't even anyway, she ended up getting awarded a $150 million lawsuit, but that's not exactly what she requested. She requested something much lower than that. I think it was 20 million or something. I think it was related to how much insurance the guy had. She wanted to just max out his insurance, just kind of slap him on the wrist and say, get the hell away from me. Well, the jury said, well, we think this is worth $150 million because of you lost your reputation and blah, 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 blah. Naked pictures on the internet, da, 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 da. And that's what the jury based it on. Judge had nothing to do with it. Lawyers had nothing to do with it. Attorneys had nothing to do with it. That was what the jury said. So as far as how the money changes hands, that can either come from the judge in a bench trial, or it can come from the jury and either the petit or the grand jury. Either one can award damages or fees, or, you know, and that's in context. The only reason it's labeled, you know, I call it litigation fees. Attorneys call it attorney's fees, right? I call it litigation fees because, well, in one of my cases, believe it or not, we actually ended up in having to defend the other side. God, it did work out that way. And, you know, we said, look, this is an integrity issue, and the court agreed, right? That was by definition defending the other side. So as far as who's more believable and who is of greater integrity, right? We didn't have to do that, but we did it because it was in good faith. It was the right thing to do. So, and you know, it's this is where I always say, you know, it's to go after and constantly attack. That's what they do. That's their shtick. That's their spiel. If you can go in and show the court, dude, that whole thing, that makes you look bad, right? That attacks the integrity of the court. Mm-hmm. If you can go in there and you can show them that that's what's happening, right? Making the judge look bad. Guess what happens? Not only are you more believable, but you can show it on paper. Yeah, you end up like where we are in that case. We're still in arraignment. So that's the neat thing about loss prevention, you know, whereas attorneys, right, they're doing whatever the hell it is attorneys do.
Yeah.
Loss prevention is there to prevent loss. And that's, in my context, it's the loss of the integrity of the court and in presentation of my client's argument, you know, their side of the case.
Would you go so far as to say rights, protecting rights, the loss of rights, the deprivation of rights?
Right. I mean, that's the ultimate goal.
Because under your little thing from Florida, creating the E-clause and all that is about the equal protection of the law.
Correct.
So the deprivation of rights is not providing equal protection of the law, the common law.
Right. So that's why I said, let's start this under the Title 42 supplement, and we'll go from there. Right. That's equal protection's premise. That's what Congress said. So,
Yep.
right. So let's just start with the equal protections of this thing, and we'll work our way forwards, backwards, sideways, up, down, whatever, depending on where the case takes us in whatever context we go. And both the court and the Congress here in Florida, they said, there's nothing unreasonable about that. Show us what you got.
Right.
I said, okay, here's what loss prevention is, and here's how it works.
Article 4, Section 1, full faith and credit to records and judicial proceedings of states. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, proceedings, and such acts, records, and proceedings shall be proved, and the effect thereof. Yes, Maria, grandparents have the right to fight for their children. It's called de facto custodial act. Pretty simple. I mean, if it's your blood, you have every right. I mean, prior to going to a perfect stranger, I mean, your family, you have every right. But I'm well aware of that kind of corruption that's going on out there as well. And like we've said before, the corruption is so deep, it's not just family law, but just so everybody is aware that what we're trying to do now is take care of all of America, which will eventually abolish family courts, because again, we're supposed to, by law, Article 3, Section 1 and 2, the extent of judicial power, Section 2. The judicial power shall extend to all cases in law and equity. That's it, right there. Law and equity, the common law and equity. Suits in equity and suits of the law, suits of the common law. That's the only two. And I mean, I have my, right here, I have my organic constitution for the state of Idaho, 1863 Organic Act of the Territory of Idaho. And it says right here, respectively shall possess chancery as well as common law jurisdiction. That is the original jurisdiction.
Mm-hmm.
That's it.
Right. And to take that answer one step further, because she said even if the case is closed, well, here's the answer to that. We can answer that with a maxim of law that clearly states no prescription or statutory limit runs against a right by blood.
That's the one. Yep.
Right. So the answer to your question is that's a right by blood.
That's right.
I can tell you that ever expires. So it is what it is.
Sorry, Chris, say that again.
Said there is that's your blood. Nobody can tell you that they can implement some kind of statute of limitations against a right that is, against, to protect you or protect them from you coming after them for interfering in your liberty interest in your grandchildren, right?
And your right, in your property.
Right.
That's a guaranteed right.
Right.
That's called bloodline. You have the right to take care of your family. That's the way things are supposed to be. It's not supposed to be the government's job to take care of your family. I mean, think about this. Let's say your kids get in a car accident, and they both die. Okay, so where do the kids go? Does the state come in and take the kids? No, the grandparents have the right to those children, because that's the common law, and that's how the common law reads. And they are the first in line of succession, bloodline, to
Correct.
take care of those children. And again, that's the common law, which is your property. But the problem we're dealing with is these aren't lawful courts. These aren't the common law courts, and which is what I'm going to be trying to abolish here in Idaho. And hopefully it just causes a domino effect. I'm going to stand up. I'm going to read them the law, and that this is not the proper jurisdiction here. This jurisdiction doesn't exist in law, not onto the states. It's not authorized. We establish justice, and that is at the common law and in equity, which has to do with real estate.
Mm-hmm.
Okay.
Right. So there is if that's a step grandparent, that's not a right by blood. That's a right by marriage.
Yeah, step's not good.
Yeah.
Bloodline. Actual bloodline.
Supersedes. Yeah, bloodline supersedes any foreigners. Hey, there we keep coming back to that word. That's right. So foreign bloodline is included in that, I would imagine, if you can just argue it.
Yeah, I mean that's what I'm going to be doing on January 10th. So just here in a couple of weeks, 3 weeks. And I'm basically just going to put them on notice that here's the law. Here's the Declaration of Independence. You know, aside from, I mean, obviously the first things I'm going to be hitting them with, and they're going to try and hit me with, is the practice of law without a license. So I'll have to hammer that one out and get that out of the way. And then once I get that out of the way, I'm basically going to say, look, you know, ignorance of the law is no excuse, but I'm coming to you with Christian love and forbearance here. You may just not know. So I'm going to afford you the opportunity to do the right thing here and perform your duties under the law. And by the way, I already have a copy of your oath of office right here, which I do have a copy of the judge's oath of office. And say, okay, first we're going to look at President Trump's deal there. And then we're going to look at Jeff Sessions' prohibition on guidance, the use of guidance documents. And then we're going to look at this expert witness here as a fiduciary practitioner's report. And we're going to go through that. And then we're going to go and I'm going to show you in law how this is unlawful. This whole court, in its entirety, family law court, is unlawful. It does not exist in law. This is not a court of law.
Right.
You call it a court of record. Well, yeah, you're recording stuff. Great. Are we talking like 45s or 33s or 78s here?
Maybe it's 8.
You're old enough to know what I'm talking about. I did spin 45s back in the day. Anyway,
tapes, brother, from like what, the 70s? Yeah.
Yeah. We spun 45s in the house and 8 tracks in the car.
Right.
In the truck.
Old. Those were the days, boy.
Those were the days. But yeah, I mean, I'm going to lay it out there and say, look, all political power is inherent to people, and we have the right to alter, reform, or abolish anything at any time. And then I'm going to take you back to the Declaration of Independence that says I have to have the right. Not only do I have the right, but I have the duty to throw off such tyranny, such government. And I'm here to throw that off and abolish it right here, right now. You've been put on notice. You're a judge. It's called misprision of felony. Misprision of a felony. I'm informing you that this is an unlawful act. This is an unlawful court tribunal, because that's what it is, an inferior tribunal.
Yep.
Okay. Acting outside the law. It's capital felony, treason, usurpation of power, by sedition, which these are all punishable by death. So I don't want to have to go that route.
Right.
Let's go ahead and abolish this court right here.
Funds for
it ends today, just like Jeff Sessions' prohibition on the use of guidance documents ends today as of November 16th, 2017. Well, as of January 10th, 2018, this type of court clear across the land is hereby abolished.
Yeah, bye. Yo fied.
And I mean it.
Yeah, exactly. So, in other words, it comes back to my favorite word, dude, y'all don't have standing to even stand there and make this and spew this crap, whatever it is you're spewing. Because, first of all, there's been no trespass of anything written in law. So you can't show where I even violated a law based on an allegation that is so ridiculous on its face. You know, wait, what?
Yeah. So are you actually using law here, or are you talking about your guidance documents, statutes, rules, regulations, and policies?
Yes,
because that was polished November 16th by Jeff Sessions.
Right?
So
I'm a bad influence on you, bro.
Well, I'm seriously, I am sick and tired of the tyranny. And like I've told people before, okay, you know, I've been studying law, researching history of law and stuff since 1995. I've been at this for over 20 years. I'm well aware, I'm wide awake of corruption, worldwide corruption. Trust me, there's a lot of things that I do not talk about on here. That doesn't mean that I'm not aware of what's going on out there in the corruption. Trust me. Yeah. There's probably some things that I'm not aware of. I mean, crap, there's so much crap out there to try and learn and figure out and research, and not just go, oh, well, this one website says something. You get down to the bottom of the website and said, oh, this is just satire.
Right.
You can't take satire as reality and truth and fact. And here's the evidence to support it, when the disclaimer in the bottom is it's just all about satire. So
right.
Be careful what you do read. And, you know, what's the old saying? Only believe half of what you see and none of what you hear.
Right.
So, you know, there's truth to that old fashioned tale, whatever statement.
Right. Samuel Clemens, Mark Twain, he said that best. He said, if you read the newspaper, or no, if you don't read the newspaper, you're uninformed. If you do read the newspaper, you're misinformed. Yeah. So talk about double whammy. Yeah.
and then there's always the, you know, I learned something new every day. And today I learned that what I learned yesterday was wrong.
Yeah.
So, and yeah, again, want to put this out there just to kind of help people understand. We're not claiming that we know everything about law. Okay. By far, there's way too much out there to try and know.
Right.
But I definitely understand the fundamental principles of law. I understand how the fundamental principles of our form of government and how government is supposed to function, what those specific duties are underneath each one of those public trust, or in a position of public office, which is an elected official. But everyone is in a position of public trust. Every single one. If you're an agent, an employee, any type of part of the government, you are in a position of public trust. We are trusting you to follow the law and not violate the law.
Right.
In fact, you're supposed to be bound to it. And all of those rules and policies that's made by your agency, yeah, those apply to you. Not to us, we the people. Again, we live at the common law. If you want to work for us, those policies apply to you, because the legislative intent in creating your agency must be adhered to. And, you know, you want to act outside of not only the law, but act outside of the policies. Yes, that's part of where those administrative hearings are supposed to be held, is dealing with internal regulations. Okay. Oh, right. Well, you did this, and you're not, you know, you work for McDonald's and you violate one of their policies. They have an administrative hearing, and you get fired, or you get reprimanded, or you get put on notice. You get suspended without pay, suspended with pay. You know, it just depends. Yeah, all based on the internal policy. That policy applies to the members of the corporation or an agent of the agency. They don't apply to people out here as law.
Yep. So basically, going back to, you know, what you do is you go in and you say, look, here's what happened. here's what the law says, right? And how are we going to apply what the law says to this set of facts, right? On this day, blah, 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 blah. And go from there. If it's reasonable, it's reasonable. If it's not reasonable, say, try again, right? So, and it's funny because people do this all day, every day, and don't even realize they're doing it when they're actually at work.
Right. So, we run into this question more often than not. It's like the most common question. Well, what do we do? Well, what do you do? They don't follow the rule of law. Can you do this? Can you help if the corruption can be proven in the state of Georgia? We are helping you right now. We're educating you because you need to do something.
Right.
Instead of sitting there saying somebody ought to do something about this, you do something about it.
Right. That's what the Declaration of Independence says.
Right. You have not only do you have a right, but you have a duty to throw off this usurpation of power, this despotic government. You do. We do. Okay. I can't be everywhere in the United States, defending every single frickin' state, defending every individual. I'm putting this out there again. I'm getting local. I'm working local. That's what I can do, and that is what I'm doing. The other thing I can do is come on here every Monday night at 6 p.m. and usually 6 to 8, and sometimes we go over. We keep talking. It's just the way it works. But this is what we're doing. We're trying to educate you on what the law is, what the new stuff that's coming out that's going to aid us in overthrowing this despotic government.
Right.
You've got to pick this stuff up. You've got to read it so that you know what it says, carry it with you, and go talk to your representatives and inform them, hey, are you aware that the Declaration of Independence is actually law? Ignorance of the law is no excuse, but I'm coming to you man to man, and I'm trying to educate you, obviously, if you don't know, that the Declaration of Independence is actually law. And in fact, it's the supreme law. It's protected under the 9th Amendment.
Right.
Article 9 of the Bill of Rights.
Right.
Those are other rights retained by the people, and they shall not be denied or disparaged. There's no legislative intent that allows to create legislation that would deny or disparage any other rights that we claim. That's the thing we need to understand here is we claim. We say what the law is because we're the ones that establish justice.
Right.
We have this property. This is our property.
Right.
No one can trespass upon your property and deprive you of any of your rights without due process of law that is due to you in accordance with the Bill of Rights, the 4th, 5th, and 6th Amendment. The 7th Amendment, if you're in a civil situation, right to a trial by jury.
Right. This is where the body politic comes in, because you got to remember when you're going in and you're talking to your representatives, they have the thing that they interchange is not money, cash, like you would think of in the conventional sense. Their goal from the time they get elected is to get reelected, right? So the thing you need to convey to them is, look, you want to get reelected, okay? What you need to show is that, you don't have skills in, writing new law, okay? Or, writing some new bill or some new statute that's unenforceable anyway. And what you need to show is your knowledge of what we currently have, your ability to work with it and enforce it and make sure that it's enforced. Mm-hmm. The 2016 election, is one of the commonly asked questions I get is what my assessment is of it. And my assessment is this: the 2016 presidential election was the election where the people came out and said, look, we want our country run like a business. Businesses make money, right? and businesses also operate within what the law says, right? You don't even have to tell a company what the law says. The company's business policies and ethical practices, here we go with that, they're written in such a manner, and we have, we have broken this down into so many categories at the corporate level. So in other words, the bigger the corporation, the more line items you have on your profit and loss statement to ensure that that company continues and you have a job to come to when you come to work every day. All you got to do is just make sure you do the job that we hired you to do, right? And if that's now, whatever it is, if it's customer service, you do that. If it's cashier, you do that. If it's pushing shopping carts in the parking lot, guess what? I did that at some point, working my way through college. So, you know what? I'm not above pushing shopping carts for a living. Been there, done that. So, it's it's all about doing it and doing it the right way. And that's what we want. That's what we're doing. We're walking in and we're telling them to do. What these people are doing ain't the right way.
Yeah.
I mean, it is what it is. I don't like it any more than you do, but that's what the people said. People said they want their law enforced. We don't want a whole metric shit ton of new law, right? That only adds fuel to the fire.
Again, go back to constitutional law.
Right.
There is no authority to establish or support or manage fundamental rights or natural right. Period. There is no authority. That was not delegated. Nowhere in any constitution is there an authority delegated to create statutory law regarding natural rights and fundamental rights, civil rights, fundamental rights, the law of the land, supreme law of the land. There is no authority. None. Right. So your neighbor can't decide that they want to create a bill regarding parental rights because parental rights come from the law of nature as a natural right, which have nothing to do with the establishment, support, or management of government. This is a common law right. So it must be heard at the common law, in the common law court. Like the Seventh Amendment says, suits at the common law. So there obviously is supposed to be a common law court here. Where is the common law courts? Well, any court can be converted or turned into a common law court because it's the law that is the jurisdiction. Correct. Okay.
So, and that's where a lot of people, they run into that confusion, because it's, well, in our state, the family court is this way. In our state, is it New York that one of it is divorce court and one of it is family court or something like that. But it's the same thing, just with a different name. Am I did I get that right? So, drive me crazy, so I would literally have to ask every 10 seconds, which court are we in anyway? Just so I clarified. So, if we're in a common law court, equity court rules don't apply. If we're in equity court, common law rules don't apply. So which court are we in here? And,
what's funny is in my Idaho Constitution, they abolished the common law and the courts of equity.
Yeah.
So, I mean, what's left? Admiralty jurisdiction and maritime law, the law of the sea. That's, the Declaration of Independence is, I'll take you all the way back to 1775, the Declaration for the Necessity of Taking Up Arms. Okay. They talk about that admiralty jurisdiction being extended onto the land. And that's a part of the reason why they declared the necessity of taking up arms, which is actually where the right to keep and bear arms comes from, as first declared in our succession of law.
Yep.
The Declaration for the Necessity of Taking Up Arms, July 6th, 1775. It happens to be almost exactly 1 year to 2 days apart that the Declaration of Independence was established and signed, with July 4th, 1776. So July 6th to July 4th, almost 1 year apart. Okay, so you have to understand what they went through in that 1 year time. And this is where the Virginia Declaration of Rights, which is established in law, is the theoretical foundation of all government. Because back in the day, in 1608, we came over from Great Britain, brought lots of money and their titles of nobility and their bloodline, and brought the Magna Carta with them over here. And that's why today, right here, right now, the law of England, the common law of England, is in full force and effect, so long as it is not repugnant to the constitutions, our supreme law of the land. Okay, so long as not repugnant to the supreme law, your state constitution. Yeah.
Which brings me to my obvious
the
question.
supreme law of the land is null and void from its inception, and not necessarily have to go to court to brand it as unconstitutional. It's not, like Chris Hallett says, it's not necessarily voidable as much as it is void from its inception.
Right. So, which always brings me back to my favorite question, was when you get into that, the law of the sea. You're in Idaho. That's a landlocked state. How are you going to employ the law of the sea on a landlocked state?
Well, you see, when they extended admiralty jurisdiction onto the land back in 1845, actually what they did is they raised the artificial sea level. It's around 10,000 feet now, because that's about the highest point we have here. I think that's down in Colorado, around 10,000 feet.
So that, that level, is that where the swamp? That's the swamp shit level. Is that what that?
Right, that is the swampish area. To be honest, the whole freaking world is a swamp. Yeah. In the context of draining the swamp.
Right.
This such atrocities around the world, and it isn't just family law. Again, I mean, there's people being shot and killed in the streets. There's some countries that aren't even allowed to have arms, and they're being attacked in the streets. They're being raped in the streets. They're being imprisoned, false imprisonment, false arrests. Well, so-and-so said, great, where's your affidavit of truth? Oh, speaking of which, this just triggered a thing for me. Another thing that we can do, it's called a protest. Imagine that. It's actually, we need to understand what a protest actually is, and it's a written declaration, an affidavit of truth signed under penalty of perjury that a moral wrong is about to happen or has already happened. So this is another thing that we can do, this whole DOJ letter thing. This is separate from the DOJ as a personal complaint. But what you can do is, if you're aware, this also falls under misprision of felony, which is Article 4, or not Article, was it Title 4? For Title 18, Section 4, United States Code. Misprision of felony. Okay, you have to inform a judge of some sort of felony that's happening. So capital felony treason under Title 18, Section 2381 through 2384 there. Okay, those are all declared acts of tyranny. All of this stuff in the Declaration of Independence and what's going on in our country. Now that you know, okay, you can write a protest. I mean, this is the part about educating the people on what an actual protest is. Okay, it's a written declaration. I don't know in my 9th edition if it's going to read the same way as my 6th. But you can write up and say, okay, I witnessed this happening. Okay, and if you go in as a court watcher to a court and you watch, say, a contempt of court hearing in a family law case, okay, that's supposed to be criminal in nature. Contempt is supposed to be criminal in nature, not civil in nature. So how do you hear something criminal in nature in a civil family court? And not only is it not, it's a family court, it's not even actually civil court. You're not even following the civil rules of procedure. You just make up your own frickin' rules of procedure. And like in my state, Rule 101 specifically says, for divorce, blah, 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 accept contempt. But here they are, filing contempt charges against my buddy for failure to pay child support. And then they say, oh, well, you have the right to a court trial, and but you don't have the right to a trial by jury. So if I find you guilty, those are the words that came right out of her mouth. If I find you guilty, you can go to jail up to 30 days per violation and up to a $5,000 or $500 or $5,000 fine. Really? When you decide if he's guilty. I'm sorry, but where in law does it say the judge can find anybody guilty?
Right.
Virginia Declaration of Rights, June 12, 1776, specifically says the right to a trial by jury shall not be infringed, basically. And how that actually works is it's a jury of 12 of your peers, of your vicinage, and you're not allowed to be found guilty except by the consent of all 12. That's what is meant by beyond a reasonable doubt. Mm-hmm. And it's to find you guilty, to consent to finding, again, back to self-governed. We are by consent. Nothing happens. That's due process of law.
What about
nothing happens
juries?
To your fellow man because you have a right and a duty, to protect your fellow man from a despotic government as part of your right to sit on a jury, to not only judge their guilt and consent to finding them guilty, but also part to abolish law. That's part of our third vote. Okay? You vote your representatives, you vote things to enact law that apply to the agencies, and the third vote is sitting on a jury. And I hereby abolish this by the power of the jury. Whatever it is you're trying to impose here, that's contrary to law. And the way, however you're trying to use it here is in an unlawful manner. And however you're trying to use it, I hereby abolish that. That's the power of the jury. That's your third vote. Now, for protest, I mean, these are pretty much things that you can write up pretty easy. A formal statement or action expressing dissent or disapproval. Under some certain circumstances, a protest is lodged to preserve a claim or right. That's what a protest is. A protest isn't standing on the street corner with a sign. That's not protesting.
You want me to give them an example? I have one.
A formal statement in writing disputing a debt's legality or validity, but agreeing to make payment, blah, 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 blah. It doesn't really say, and yes, go ahead and pull that up, but I'm still looking for the one. I may have to pull up my Black's Law 6th edition. I'm
actually looking at my amicus brief that I filed back in April of last year. It was one of those deals. It was my first report or protest to Congress that doubled as an amicus answer brief in my monopoly challenge case. So knowing that I can take and accomplish, I can walk and chew gum at the same time, I prepared this amicus brief. Basically in protest, I prepared it's got 2 cover pages. First cover page was the typical one to the court. The second one was to Congress as a citizen petition under Title 15, Chapter 53, Subchapter 1, Subsection 2620, which is citizen petitions, right?
Right.
And at the end of this petition, I declared for I made a declaration for a vote of no confidence against the bar.
not only is there no confidence in the bar, they lack all integrity because, again, their first line of allegiance as an officer of the court is to the court, never
right.
to you as the man defending your rights. And again, if you actually read impropriety persona in the dictionary, if pleaded by an attorney, they admit the jurisdiction and then take leave, which means whatever happens from here on out happens to this schmuckatelli over here next to me. It don't happen to me as your attorney, as the attorney of record. Everything happens to this guy over here. Not only that, when you hire an attorney, what you're actually telling the court is you're an idiot. Okay? By law, That's
Right.
what you're saying. That's what you're telling the court, that you're so dysfunctional and you're not able to handle your own administrative duties here.
Right. So anyway, let me explain to you how this actually happened. In the first case, the monopoly challenge, it pissed them off so bad that the district court judge forgot to assign counsel to the U.S. government.
Yeah.
Talk about a faux pas, right? So
would that be a clerical error or mistake? Rule 60B.
Yeah, right. So as far as the amount of crap he was in, it was okay. Well, let's see. How do I do this? Well, okay. Well, that must mean you want me to act as counsel for the U.S. government, which was how I devised the idea for the amicus on behalf of the people. So here's why the declaration for the vote of no confidence. Here's how it reads. Herein, and by full authority and standing, as the only advocate for the people in this matter, which is Christopher Hallett versus the state of Ohio regarding the monopoly issue, make this formal declaration within this 115th Congress of the United States of America, through proceedings and evidence brought forth, the current legal monopoly has become hostile to its intended purpose and breached its statutory duty to the Republic, right? A redefinition and replacement of this entity has become necessary to ensure the continuation of this republic. The Declaration of Independence and the Constitution of the United States remains intact, right? Therefore, I, Christopher Herbert Hallett, born United States citizen and current resident of the state of Florida, county of Marion, city of Ocala, hereby exercise my full legal authority and move for a vote of no confidence against the current practice of law, right? Also known as the bar under Article 4, Section 4 of the Constitution. See estoppel by conduct for details on the redefinition of relationship of the practice of law to the people. And I included a copy of that. But that's an actual protest, right? So when you talk about what you want, you say you're going to come in and I'm going to blah, 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 blah. Well, what do you want them to do? You make a declaration for what you want them to do, right? Whether they do it or not, it doesn't matter. Like Kirk said, I wrote an amicus brief, put my credentials on it, same as I did before. And because I was the counsel for the people of the United States, here was my solution to this problem, right? So, this was shortly after Trump was inaugurated, and I couldn't resist. I had to put the Make America Great Again in there because I knew it would just piss him off. And it did. But, the fact of the matter is, you want to go in there and you want to, it's one thing to create civil unrest. It's something else to walk in there and literally show them on paper, look, I know you guys think you're smarter than the rest of the average bear out here, but I can tell you, you're not, right? And as far as claiming my rights is concerned, well, guess what? I've already done that. You don't have to tell me that that I can't do that. It's not your job to tell me that I can't do that. I've already done that. And because I've done that, and am by default the counsel for the people in the matter of Hallett versus Ohio, which is the reason that we agreed to redo it as an emoluments case. And go ahead and make it as a formal quitom, which is what we've done. We agreed that the first run at this was to say you can't have monopoly. Yeah, you're right. We can't have monopoly. What do we got to do? Okay, here it is. And but I had, part of that protest, that declaration, that fit right where you were talking about. So you protest to Congress, you can find a rule. The two that I used, first one was Title 15, Chapter 53, Subchapter I-1, Subsection 2620A, Citizen Petitions, right? The second one I used in my report, right, was, because it went to a different area of government, different area of Congress, different committee, I used 28 U.S. Code, 2201, 2202, and 2415. So, it's all in, which of course is Judiciary Committee, blah, 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 blah. Those were the guys that needed to be addressed in that report, was the House Judiciary Committee. So that shows those rules. Mm-hmm. So, I
just wanted to put this out there that, this is another thing that can be done to aid somebody else.
Right.
And the fact that a protest is not what you think it is. And this is part of the problem we're having, is that people think you've been told, you've been taught that this is what a protest looks like, except for in law, that's not what a protest is. So actually what you think is a protest is actually exercising your right to peaceably assemble, so long as you're not causing a breach of the peace, which is an arrestable offense, by the way. Okay. The only other types of arrestable offenses without a warrant is heinous crimes, rape, murder, domestic violence. And all of that has to happen directly in front of the arresting party, okay, to stop whatever it is, to stop the rape, to stop the murder, to stop the heinous crime, okay? And I have law on that, and I've put that out there. I have that in Kirk's Law Corner, a treaty on arrest and false imprisonment, breaks that all down. It even gives the law part of it where, they're not allowed to make statutory law regarding due process of law. That comes from the law of the land, not from statutory law. There's actually absolutely no authority, again, because why? Because where the rights come from as a fundamental right have nothing to do with the establishment, support, or management of government. So with that, we're out of time basically for tonight. Crystal, you're here. I didn't even hear you. I brought you in, but I didn't hear you say anything. So if you want to say something.
Sorry, I was driving home, and I just wanted to listen tonight.
You mean you were traveling?
So how are you guys tonight?
Pretty decent, Crystal. How you doing, darling?
I'm good.
Doing good. How are you?
Was at the library state office, the state substance to the state of Utah. Love it. Printing out my evidence.
There you go.
That's what it takes, folks. You have to do your studies.
Right.
We can't do this for you, and nobody else is going to do it for you either. You hire an attorney.
Nothing.
Well, those of you that have hired an attorney, you know what happens. They take your money. Oh, there she goes.
Yeah, she dropped the call. She must have hit her dead zone.
Yeah. So, I mean, that's the thing. I mean, think about this for a second. Attorn is the root word of attorney. That is to take your property and give it to somebody else. That is what attorn means. And that's who we are hiring, is these attorneys. Okay? And so here's a clear distinction between an attorney and a lawyer, because a lawyer is one who is knowledgeable on the law, one who speaks the law, a law sayer. That's what a lawyer is. It's a pronoun. It's two words put together, law and sayer. That's what makes a lawyer. So please understand the difference. Please.
I love you.
It drives me nuts. Because I consider myself a lawyer, a law sayer. That's why this is Kirk's Law Corner, because we talk about law.
Right. We're not attorneys. We don't take jack shit from anybody and give it to anybody else. We just say, What the law says. That's got to be our slogan. What the law says.
As it is written. Because, you know, the law doesn't say anything.
Right. Yeah, we have to say.
When you speak it, it sure the heck does.
Yep.
And the law is what we say it is.
Right.
That's how that works. Because, again, the government is a figment of the imagination. It only exists on paper because we put it there.
Yeah.
Other than that, it's supposed to be self-evident that you can't do that to another man. You can't do that to another human being. That's, you know, we're supposed to know the difference between right and wrong here. Self-evident.
Right.
Okay? You should have some sort of guilty conscience when you do something wrong to another man.
Mm-hmm.
Should.
Right.
Should. I wish more people would.
Right.
But
But they don't. It's a greedy world is what we live in.
Right.
Trying to come to people with Christian love and forbearance and say, look, you know, I understand that ignorance of the law is no excuse, but, you know, I want to afford you the opportunity to be educated here and do the right thing. So let's start doing that, folks. Let's start grabbing this law, you know, the proclamation, the Jeff Sessions letter, the Declaration of Independence, the Constitution, your state constitution. And guess what? Every single state constitution has a Bill of Rights in it as well. And that's protected under Article 4, Section 1, 14th Amendment. But I like to use the Constitution by far more than the 14th Amendment. I actually despise the 14th Amendment because I actually know what the 14th Amendment has done to our country and turned us all into slaves. But like I said, there's a lot more knowledge up here.
Brave.
I either lead on.
Not if you don't read Harvard versus Rican. They're all about the 14th Amendment.
I'll just refer you to Hale versus Hinkle.
Yeah.
Right. And I'll say Harvard versus Rican because that was more prominent and more recent.
Oh, you kids.
Have you read Hale versus Hinkle?
Harvard versus Rican. Can you spell it?
IT.
Yep, IT.
Right.
Kitties. Kitty caca. No, you ought to look at Hale versus Henkel. Henkel. Basically, that's your right to contract your labor as you see fit, and you do not have to, you know, Fourth Amendment, you do not have to give up your personal private documents, personal contracts between one man and another. They are not, they're not allowed to be searched or seized, because we are not, we the people are not bound to disclose our personal private matters. That's what the Fourth Amendment is about, is being secure in your persons, papers, and houses and effects. You have the right to be secure, okay? Like a frickin' lock, like President Trump just put out. They are locked into the law. And these people, as an employee of the government, are supposed to be bound to uphold this stuff, to follow the rule of law. So, with that,